Hi all. Busy day, still is, and is still going. But I did get a chance to listen to the hearing that happened in the Karen Reed civil case this afternoon, and I wanted to give you an overview of what I heard because this is the first time we've really gotten to see all of the attorneys and the judge in that case and hear what everybody has to say. So, brief overview, this is a different judge, this is a different court, this is a civil case, not a criminal case. The civil case was filed, I think, maybe a year or two ago. While the criminal case was going on, the civil case was stayed. Once the criminal case was over, that stay was lifted, and the parties are now able to do discovery. Karen Reed's team and the other two bars, C.F. McCarthy's and the Waterfall, who are also defendants with her, filed a motion to dismiss, asking for a handful of the claims to be dismissed, though not all of them. And the hearing that was had today was oral argument on that motion to dismiss and also a general case management and scheduling conference. Karen was there today. She was sitting in the gallery, not at the counsel table. I'm sure she's had quite enough of that. She had, I think, 8 lawyers on her side. And then there were the plaintiff's lawyers, and then it was so crowded that the lawyers for the two bars had to sit in the jury box because there wasn't any room. And the judge noted, there's 8 parties in this case already. There's a lot of things going on here. And he sort of said, he didn't try to show his power, I'm going to keep this tight and I'm going to tell you guys what to do. But he showed that he recognized that this was a big case and this was a high profile case. And he let everybody talk, he let everybody have their say, but he also didn't sort of give in to anybody. If he wouldn't answer a question unless it was directly asked to him, which will make sense in a minute. Now, just my first impressions, like I said, the judge seems fine. He seems fine. Karen Reed's lawyer who spoke today, I had never seen or heard any of the other lawyers except Alan Jackson, who did not talk today. I cannot remember his name, but he is Irish, Scottish. I get those mixed up. I know that's terrible. But he had this gorgeous, something in the British Isles, gorgeous accent. He did fine. He wasn't spectacular. I mean, I'm judgy, but he did fine. The lawyers for the two bars didn't really talk very much. Karen Reed's team is clearly taking the lead defense. They're coming up with the strategies, they're filing the motions, and then the bars are kind of going, yep, us too, yep, me too, me too. Now, there may come a point at which their interests diverge, for sure. But for now, they're kind of all in the pot together. The plaintiff's lawyer was very typical plaintiff's lawyer. He was very dramatic. As plaintiff's lawyers always are. It's the job of a plaintiff's lawyer to say, my client or my clients have been hurt. This is so hard on them. And particularly when you've got emotional distress claims, their job is to show why this is the most awful thing ever. And it was interesting listening to him sort of talk about their overview and their summary of the case. Because in some ways, the allegations that are being made in the civil case are worse than the allegations being made in the criminal case. Because in the criminal case, obviously the standard of proof is higher and obviously the stakes are much higher. But you just have to prove that there was a criminal act and you have to prove that the person had some sort of criminal mind at the time that the act took place. But in the civil cases, they are going balls to the wall. I mean, he was like, she knew she hit him. She went home and woke the niece up and traumatized her, even though she knew that girl was fragile. She put together a conspiracy that made the O'Keeffes look terrible, and she knew she was doing it. She worked with Turtle Boy to hurt the O'Keeffes. She's the one who leaked the autopsy photos. I mean, they are going after her in a big, big way. So it was interesting to hear that because a lot of those things, even though they were sort of implied or sometimes mentioned once in the criminal case, they weren't as relevant because all that was relevant was whether she had engaged in, the very narrow definition of these crimes. But in this case, they're going after her for far more than that. And you could tell by the plaintiff's lawyer's sort of summary of the case that they're basically arguing that she is the worst person who has ever lived. The plaintiff's lawyer also did something that I have never heard before and did not like, which is he called all his opposing counsel my brothers. Now, sometimes lawyers will joke around, and a lot of times it's facetious, but like, my friends on the other side have argued this. My friends over here, like, my good friend Mike, whom I've worked with for many years, is wrong on this point, right? But he called everyone my brother. My brothers argued this, and my brothers who did this, and my brothers filed a motion to dismiss, and I was like, ew, I did not like that at all. I don't know if that's a Massachusetts thing, but I doubt it. So the big news that's going to come out of this hearing is that Reed's lawyers told the judge, they didn't really ask. They said, listen, once you get done with the motion to dismiss, whatever you rule, there's still going to be claims left because they only asked for some of the claims to be dismissed. And they said, look, Your Honor, when we go to answer, we're telling you right now that we are going to bring in a whole bunch of other people. We are going to sue people in this case. We as the defendants are going to bring in third-party defendants, and we are going to claim that those people violated Karen Reed's civil rights and that that's why this damage occurred. And they sort of teased out to the judge, like, we have a way of doing it that's not the normal way that you would do that because we realize that this is a big case and this is going to make it really complicated. And it was really hard for me to follow exactly what it was that they were doing. But it seemed like they were sort of saying, like, if that's okay with Your Honor. And he was like, you haven't asked, like, there's nothing for me to rule on. He basically said without saying, like, if you want to file a motion asking to do it differently, file a motion to ask to do it differently. If you want to brief it, brief it. But, like, there's nothing for me to say until you tell me what you want to do. So I think a lot of that was just for the soundbite of us hearing that they were going to sue all these people. Now, I'm sure it will shock no one who the people are. It's Buchanan, Proctor, Tully, the McCabe's, the Alberts, Higgins, the Massachusetts State Police, and the Canton Police for a negligent failure to secure the car in the Sallyport. And they claim they're going to bring civil rights claims against all these people. Now, that is in it of itself very complicated because, number one, those are usually federal claims, although they said, no, we want to stay here in state court. And number two, it is very difficult to sue police officers for violations of civil rights, but they clearly think that they've got a theory where they can do it. There was some argument about how they should deal with all of this in the same case because it arises out of the same nucleus of operative facts, which is all things that deal with the same facts should be tried in the same case rather than separately. So I think they're going to file some motion that it should all be dealt with in one case. And I think the plaintiff's lawyers are going to fight it and say, if you want to sue Brian Higgins, that has nothing to do with this case. And then they're going to have to hash that out and the judge is going to have to decide. The other thing was this argument on the dismissal. They did oral argument on all the dismissal arguments. I will say the plaintiff's lawyer did a better job than Karen Reed's lawyer. Now, sometimes it's hard to be the one who filed the motion because you're like, well, I put all my good arguments in the documents. But the plaintiff's lawyer did a very good job of taking apart most of their arguments and doing it with case law. And, this guy is overly dramatic and he's bombastic or whatever, but he's not dumb. He did a pretty good job, and I think that motion to dismiss will largely be denied because I think that he muddied the waters enough for the judge to say, okay, I'm not ready to get rid of these claims at this particular case. Most of the arguments are really boring. I did a video on it. They're just like, was wrongful death and negligent infliction basically the same case because the damages are the same, blah, blah, blah. One place where I think the defendants might win is on the intentional infliction of emotional distress claim, because for intentional infliction, you have to show that the person that you're suing engaged in extreme and outrageous conduct. And the extreme and outrageous conduct they're claiming is waking up the niece at 3:00 in the morning and telling her that she wasn't sure where John was and that she was worried that he might be dead. And the defendants were like, that's ridiculous. Like that, usually intentional infliction is like absolute batshit crazy stuff. And the argument the plaintiffs made was, well, you can take the circumstances into account. And this was a very vulnerable young lady because she'd already lost her parents. And so her susceptibility to having this be outrageous to her is what makes the difference. I don't know that argument is going to fly. But again, my big takeaway from this is that the plaintiffs are going after Karen and their position is she is the fucking worst. So this one's going to be interesting.